All right, everybody, welcome to Friday Night Lights. Today is Friday, 7 p.m. We run these calls. If you've not been on, I think most of you have been on before, but if you've not, we run these calls every Friday night around 7 p.m. Eastern time. And normally we run till 8:30, but tonight we are cutting it a little short. We're going to go till 8 o'clock. There's another meeting tonight. Grant's holding an investor call later at 8 o'clock. And so we're going to give folks back that time so they can jump over there and not have to do both. And so we are going to go from 7 to 8 tonight. We have an exciting topic tonight. It is the topic that no one wants to talk about, but everybody should know, and that's just some legal information that we have gathered. Teresa's gonna kind of walk you guys through that. She is our resident legal expert because she spends a lot of time with our lawyers and she just absolutely loves them. So she's gonna walk you through that. What I would like to say though is this is for educational purposes only. We are not SEC attorneys, so we are giving advice based on facts and stuff that we know. We are not here to tell you what to do particularly, but just what the law states. We're also not accountants or financial advisors, so everything on this call is for informational purposes only. And always, always, always do your due diligence. Check with your lawyers too. Validate a lot of this stuff. And of course, we always record this, and so you can always listen back to it and ask questions where you need to. We are also open to any questions you have. So as we're going through this, feel free to prompt us, ask us anything. If we know the answer, we will help out. If not, we can definitely get that answer for you. So, with that, I will turn it over to Teresa to kind of kick us off a little bit to learn
Sure.
about the SEC.
All right. Everybody's favorite topic, staying out of jail. We got to love that. We definitely appreciate you guys being here tonight. As Jason said, I am going to cover some legal information both on the transactional lawyer side and the SEC lawyer side. I've got some slides that I'm going to share with you, and we'll be happy to provide those to you along with the recording of this call. As he said, I am not an attorney. Thought about it for a little while, but didn't actually pull the trigger on that deal. Sat for the bar exam and decided that it was, or the entrance exam, and it was not my thing. But I did decide that once I got into real estate, that a lot of people stayed away from it, didn't know. Like Tim said, it's probably one that people know the least about, and I just decided that I was going to educate myself. So I joined a mentor group. I was in the mentor group with Mauricio Rald for about a year and weekly meetings on all kinds of topics. I was looking back through the information that he had shared, and there were, I think, 51 different podcasts he'd recorded. So it was nearly a year that he had put that together. So the amount of information that is trying to get into my brain, and I hope I can get that out to you. And we've worked with other attorneys as well. Since I worked with Mauricio, he sold his practice, and then I worked with the lawyers that took over. So I've worked with about 3 or 4 SEC attorneys, and I've worked with about the same amount of transactional attorneys. So again, as he said, not definitely not legal advice here, but definitely things that we think that you should know about. And please, as Jason said, as we're going through, raise your hand or put something in the chat. We really want this to be conversational. So if something comes up and you have a question about what we're talking about, please don't be afraid to speak up or put something in the chat. So here are my legal thoughts. If you notice, this is for educational purposes only. We're not tax or law professionals. So I wanted to kind of give a quick overview of the timeline of a deal. And some of these things that are very high level. There are so many things, like I couldn't even, trouble limiting it to 8, but I tried to give some kind of overreaching ideas of what is going to happen when you get to the point where you find the deal in step number 1 and you offer an LOI. So, you've got that deal, you're excited, you submit that letter of intent. and you want to go ahead and get started on some of the behind the scenes stuff. And one of the thing is a platform that you're going to run on. And we're going to talk about that a little bit. Some of the ones we've used Cashflow Portal, we're currently using Avestor. This is something that you really can't live without. You cannot try to take on keeping track of all of the legal and all of the money and all of that without having some kind of software, some kind of app program that is going to help you do it. I'm sure there's many, many out there. I personally have used Cashflow Portal and Avestor, so I can attest to those and how they operate. But do your research, and that's the kind of stuff you can do now. Like maybe it's 2 a.m. and you can't sleep and you can't call brokers at 2 a.m., but you can, do some research on a platform that's going to be able to run your program. These all important that you get that kind of stuff done early. Not that that is necessarily a step in the legal process, but it's going to make the steps in the legal process much smoother for you. So once you get the approval on your LOI, so let's say you got an LOI in and the seller says, yep, we're going with you. We've signed off on it. All the rest of these steps, 2, 3, 4, 5, 6, 7, 8, literally need to go bam, 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 bam. And they're not even really in sequential order. They are on top of each other. So this is just a high, heavy, lots of stuff to do. But we're going to walk through them one at a time, and then we're going to get into more detail throughout the presentation. So immediately when you realize that your LOI has been accepted, you need to hire 2 attorneys. One of those attorneys would be called a transactional lawyer or a PSA attorney. Sometimes they're called different names. These are people that specialize in real estate, but they are not SEC attorneys. So the PSA attorney is going to help you get that purchase and sale agreement done. Now, when you're in a buy-sell situation, your seller may be doing the PSA. You may have said that on your LOI, or you may want to do it yourself. I've heard advantages and disadvantages of doing it one way or the other. Of course, some people like the control. I think it kind of depends on how quickly you can get your attorney to move. If you have an attorney that, takes his good old time, then you may not want to do it yourself. But if you have an attorney like our SEC attorney that we just worked with this last time, Michael Fugler, I was on the phone with him at 5:30, 6 a.m. in the morning. He was an early riser and he got stuff done. So the transactional attorney is the first call you're going to make, and then an SEC attorney. In most cases, I'm not saying there isn't anyone out there who does both, but for the most part, these are not the same attorney. An SEC attorney specializes in SEC compliance, obviously. So once you get that PSA, step 3, you're going to get it created or approved. Then you're going to be able to use that time, because once you get that LOI approved, then you have a little bit of a period, maybe 2 to 3 weeks, where that PSA is either getting drafted or it's getting approved in your case. So you're reading through it, doing that. This is what I'm calling grace time, okay? This does not count against your due diligence period. It doesn't count against your financing for 30 days. So you really want to take advantage of this time. You need to just hurry fast and get stuff done. So make sure that you take advantage of that gift of time, that free time. And in this case, you need to make detailed decisions, because these are the kind of questions that the SEC attorney is going to ask you. And these are probably questions that maybe if you haven't even done a deal yet, you may not have had these discussions with your partners, but you need to. So just some things I thought of real quick that I threw out. What's your waterfall for investors? And we can, talk more about that. How are you setting up your GP team? So in other words, is everybody an equal partner? Or are you splitting it up differently? You can be equal partners in the business, in the LLC, but don't take the same shares. So there's all kinds of those kinds of questions. And these are the things that are going to have to be fully answered and disclosed. Who has what responsibilities? What are the fees involved with what you are doing on this transaction? We'll talk about fees a little bit more in a bit. What bank accounts are you going to set up? You're going to have to set up 2 for sure. you're going to have a fund bank account, and then you're going to have a fund manager bank account. And of course, LLCs go with those when you set those up. The great thing about this is that if you get the right SEC lawyer, they will help you through these things. You just got to be sure you ask questions. Don't be afraid. This isn't an area where you can just, well, I kind of think I know what I'm doing. I heard Teresa talk about it, so I think I know. No, get that SEC lawyer, ask questions, make them, I mean, don't feel stupid. I mean, some of the questions I ask, I'm sure they were rolling their eyes at me, but I wanted to be sure that I understood. And as we move into step 5, we want you to prepare to attract capital. Capital raise. Reach out to friends and family if you're doing a 506B. Prepare your marketing if you're a 506C. Now, notice I say reach out to them, but you're not going to run to them with a bunch of numbers that you've done your underwriting with, because the SEC lawyers will slap your hand if they find out that you have shared any information with anyone, 506B or C, if you have not first got the SEC documents in place and gotten all of your ducks in a row. So the best thing to do is when we realized that we had, signed our LOIs, we call friends and family, people we've already talked to, maybe previous investors, people that are in our network of circle, and say, hey, exciting news. We got this deal in St. Louis. We're going to be moving on it. We're working on all of the legal paperwork, but I want to give you a heads up. Let's set something so that we can talk next week and I'll be able to give you all the details. So as much excitement and generation as you can do to get people moving, then that's what you want to do during this time frame, because it's going to kind of feel like you're hurrying up and waiting, because you're hurrying up to get all this stuff going, but then you're waiting for the lawyers to actually get it done. And that doesn't mean you shouldn't be doing anything. You're, creating that buzz in your network to let people know that, hey, something's coming, get ready. And of course, if you're doing a 506C, which we'll talk in more detail about the 506B and C and the differences, then you want to go ahead and get that marketing prepared. Are you going to do social media? Do you need to get landing pages up on your website? Those are all things that will come into play if you're doing a 506C. And of course, you're going to create that pitch deck. A lot of us have seen pitch decks, done pitch decks. The SEC attorney will have a say on what goes into that pitch deck. If you notice, we have our disclaimer on page 2 of the pitch deck. That is courtesy of the SEC lawyers. We know that it's not super pretty to be right there in front, but we also know it's not super pretty to be standing behind bars. So we definitely put that page up front and let people know that, this is the investment that has risk, as do all investments. And again, the SEC attorney will help you through that information as to what you should have there. They will read everything and sign off on it. So, and again, I'm moving through this really quickly. This is an overview. We're going to talk a little more detail on some of these, but please, if you have questions, just raise your hand. I can't see Jason, so please call on somebody if you need to, or
Yep. So
answer
far,
any questions. Okay,
so
good.
far, so far, no hands
And
up, and
then,
we definitely agree. You
so
definitely, don't look good behind bars. So,
yeah, thanks. Like that. Um, so on number 7, you're going to get all that info uploaded to whatever platform you choose to use. So the cash flow portal, and if you're not familiar with how those platforms work, this is another great reason why you should be an LP before you try to GP, because this allows you to get into one of the platforms like cash flow portal or Investor, so that you can see what it looks like from the other side. We all have those software programs that we use that we know what it looks like on our side, but unfortunately on the user side it looks a little different. And if you've already gotten in there and done an investment on your own, then that's going to make much more sense when you start loading your own deals information into the platform. And again, I will reiterate, first I thought, maybe I can just track this myself. And once I realized what everything there is to track, that's just not even sensible. It doesn't make any sense. And so this is definitely going to be, an expense that you're going to have to get that set up and going. And then number 8, raise, baby, raise. Plan weekly meetings, personal invites, call everyone daily, have, daily call goals that you're working with, create contests and games so that you either push yourself or you push your teammates, whatever the case may be there. So definitely lots in that one slide. There's so much more I can go into, but I wanted to give a quick overview of the timeline because I think a lot of times people don't even understand. I've heard people on calls before say, well, I've got my LOI and we're, going to be doing due diligence next week. And I think maybe I should get an attorney. And I'm like, okay, wait, that attorney should have come, soon as that LOI was signed off on, that is when you want to get that attorney. So definitely, you got to plan ahead.
So, a couple folks would like recommendations for SEC lawyers, so and where we got
Okay.
them. So we can send
Okay.
out Michael's information.
Yeah, we'll send out Michael's. I also have worked with, as I said, Mauricio Rald. He no longer practices. However, the law group that he formed, he sold to his partner, and that's Premier Law Group, and they're an SEC firm as well. So yes, we can definitely provide that. We'll include that in the follow-up. Thank you, Jason. So this is just a little bit of further detail on the attorneys that you're going to need. That transactional lawyer, which we've already talked about, that will do the purchase and sale agreement for you, and the SEC lawyer. Now, the SEC lawyer, in addition to kind of checking over all of your documents that you're using, like your pitch deck, they're going to create what you probably have signed as an LP investor. Well, you would have definitely signed it if it's a syndication, a private placement memorandum, a subscription agreement, and an operating agreement, often referred to as PPMs, SAs, or OAs and OAs. Our current PPM, SA, OA is combination. It's all in one document. They are separated out, but it's in 112 pages. And we have read through these pages. And if you ever have a investor who asks questions, you're always appreciative when you have read through it so that you act like or sound like you know what you're talking about. I definitely have a few that are avid readers and they have put me on the spot a few times. And I was thankful that I had read through it and could answer their questions with no problem. So these are just the overview of the attorneys that you will need immediately.
So there was one, sorry,
Yep.
Satori, I think you had your hand raised before. Can't, can you guys, I can't really hear you unless somebody else can, maybe me.
I can't.
Can I hear me? Hello, hello.
Oh, we can hear you, but it's very low.
Sounds like your microphone's a long way from your mouth.
Yeah. Uh,
Can you hear me now?
Yes.
Yes.
Yeah, there we go.
Yes.
Okay, beautiful. Yeah, no, at first I thought I'd wait till all the slides were done, but so the question I have, you said something, I think it was seven or eight, six maybe. When talking to people and getting them excited and sharing about this, are you, oh yeah, create the pitch deck. So when I'm talking to people that I want to get on board to be able to with me. I can't tell them about numbers specifically. Is that what you're saying? But I can share about a specific property, a specific deal.
Right. So until you have your SEC lawyer, all of your PPM documents ready to go, technically you cannot talk to someone. So you would not want to quote any type of numbers. But you can talk to them about the deal. Hey, it's in St. Louis. We're really excited about it. It's in a great area. You can talk general, but you cannot say it's going to be 8% return because all of that has to have the disclaimers attached to it when you start talking about that. So stick to the facts. Don't talk about projections.
Got it. But can I tell them how much we're trying to raise? We're trying to raise $1 million, $5 million.
I wouldn't do anything with numbers until you get that sources and uses, which of course the SEC lawyer is going to want you to have a slide in there that has sources of funds and uses of funds. And again, that's a little bit of a touchy area because that's not fact, right? It's a fact that you're buying this property in St. Louis. I wouldn't even go into how much you're paying or anything like that. I would just make it really, talk about location. You could talk about the schools that are in the area. You talk about all the business or, man, I've seen this property. It is fantastic. Anything that's emotional, but stay away from numbers.
Got it. Okay, perfect. Thank you. Once
Uh-huh.
so when you are doing the when you hiring the attorneys, it doesn't matter if the SEC what state they're in, depending, or it needs to be a state that where you are actually investing in.
That's a great question, Satori. It does not matter because SEC is a federal ruling. So it doesn't matter. And so those SEC lawyers, if they're truly SEC lawyers, they are for over the federal. So any state is fine. I know that Michael lives in Florida, the one that we used recently, and the previous one I used was in California. So it makes no difference. And my property was in Texas and in Missouri, and so it doesn't matter because it's a federal regulation.
Beautiful. Thank you.
Okay, you're
So,
welcome.
so to add to that, Teresa, what about the
Yeah.
transactional attorney?
Yeah, same goes
Or
for that. A lot of times it's really nice to use a transactional attorney that is close or understands the location and the property. When I did my deal in Texas, I did use an attorney right there in Houston. They know the Texas laws. It makes more sense for you to do that, but you don't have to either. But I have found, I know for our deal in St. Louis, we did use an attorney, a transactional attorney that was in Missouri. So I'm not saying that you have to do that, but that is what we found that makes the most sense because those kinds of things they're putting in that PSA, those are important that they know, some of the surroundings about what's going on in when they put the language together. So I really liked how that worked out. As a using the SEC anywhere and the attorney, the transactional attorney in the state. We good? Thank you.
Yep.
Those were great questions. Okay, so this is probably one of the most discussed and um, maybe misquoted, the 506B versus the 506C, and that comes in under Reg D. So what that all means is there is a law, of course, by the SEC that if you're going to sell financial instruments, that you have to be a financial advisor. You have to be licensed with securities, right? So that would be the normal financial advisor that we're familiar with, whether it's at Merrill Lynch or Wells Fargo or whatever. That they are regulated. However, there is a Regulation D where we can file under the special rules that allow us to sell securities as long as we follow these rules. And these rules are 506B is generally thought of as a non-accredited person. 506C is generally thought of as a accredited person. Now, what's the difference? Accredited investors, which you can see on the right-hand side there where it says the 506C rules, accredited investors only. The requirements for them at this time is that you must have $1 million in net worth without including your home. You can't include your main residence. You can't include investments, or $200,000 in net income, gross income over the last 2 years. They did add another way to qualify just this last year, probably just about a year ago now. I think it was in February of 25, that you could invest in a deal. And if you invested $200,000 or more, you were immediately assumed to be an accredited investor. So people who don't fall into that category are their only option is to come into the 506B. And if you notice that on the left-hand side, these are what we would normally call friends and family. So these are people in your circles that you know or that your partners know. We cannot generally solicitate. We have to have a pre-existing relationship with these people. And that means that it's existing before you sign the PSA agreement. Okay, so you have to have already known these people. So if there's somebody on the call, Satori, I don't think I've spoken to you before. So if you happen to fall in the 506B, and maybe one of my partners have, but if you're in the 506B and I haven't spoken to you and I already have a deal under contract, I cannot put you in my deal. If you're a 506C, if you're accredited, that's absolutely fine and we can put you into the 506C. 506B, non-accredited people cannot go in to a 506C offering. However, accredited people can go into a 506B or a C. You'll notice some other things is that up to 35 non-accredited investors would be allowed. Um, if you are accredited, 506B allows you to self-certification. In other words, you can say, yes, I am, and then you provide a letter from your CPA or lawyer that says that you are indeed a accredited investor. Heightened disclosure. This means that there are some additional reporting that we have to do for 506B investors so that they are well informed on what is happening in the investment process. Of course, we cannot do ads, cold outreach, or paid funnels. It is a quiet relationship driven raise. So really, if you just think of 506B as friends and family, that's what is mostly made up of with that 35 non-accredited. Like I said, you can bring accredited in at any time. There is no problem with that. So kind of on the flip side then, the 506C, we can generally solicitate. I've already talked about what the accredited investors, we have to reasonably do verification that we know that they are accredited. So when we do our interviews or talk to people about investing with us, those are the kind of questions that we would ask to get a reasonable analysis as to whether this person was a accredited investor. Of
There's
course, we can use our websites. Go ahead.
there's one question. Does JV fall under Reg D?
Yeah, that's good. It's a good question. Um, the joint venture is a little bit different. The JV, as he or she noted it, it is a little bit different. It is not in under the same regulations because it is a joint venture. Now, however, there are still regulations you have to follow. One being, and this is one that I think is often misconstrued. People tend to think that if you're in a joint venture, you can be a silent partner. And technically, everyone in a joint venture, according to SEC compliance, must have a job. So, your job could be advising, bringing donuts to the meeting, whatever that the job is. But everyone in a JV does need to have a position, and it doesn't have to be equal, but it does have to have some kind of a substantial position. So they do not fall under the 506B or the 506C rules in a joint venture. So it is definitely a little bit different. Thank you for asking that because I had it in my notes and then I remembered I forgot to put it in the slides. So I do appreciate you asking that question. Any other questions, Jason?
Michael also mentioned under a 506C, you can also accept a Series 65 certification for accreditation.
That's a great point. Absolutely correct. Yes. Yep. So again, on the 506C, anything's open. Social media posts, websites, self-certification cannot happen. We have to have some documentation in order to prove that that person is accredited. I said that normally comes in the form of a CPA or a lawyer. On our raise that we just did, I actually had a investor whose CPA refused to do the accreditation. She cited that she did not want to be liable. So, I mean, we have other options. He is accredited and it's no problem. But it was just interesting to me that she wouldn't sign off on a letter, which I think is funny because he owns 50 single family homes as rentals. And I think, okay, well, it's not like it's questionable whether he's worth $1 million or not. But anyway, they just know that those roadblocks are out there.
So you have a line of questions coming up right now. So
Okay. Okay.
I think Elaine, you were first.
Hi. So with the 506B, if you're raising a significant amount of equity, and then you have your minimum at 100,000, let's say, if you need like, let's say you're raising 7 million, so you have a minimum of 70 um, investors, right? You can have like 100,000 each, so 70 investors. Because the 506B caps it at up to 35 non-accredited, you can
Right.
only, I mean, is that the limit? So you can only have the 35 non-accredited in that case,
Yes.
and then you will have to get the other 35 from accredited?
Yes, that's correct.
Okay.
Yeah. So you either need to raise your average with the non-accredited, or you need to get accredited investors on the other side. You're absolutely right.
Okay. Right. Thank you.
You're welcome.
And then John, you're up.
Yeah, thank you. I was asking about the JV, and I was just curious if the if you're if you have a company want to invest in your deal, how does that company have to? I mean, they're probably most likely an LLC. How would they come into that deal? Would that be a JV, or would that company be considered one of your investors? Does that make sense?
Yeah. So absolutely, I understand what you're asking. There's always multiple answers, right? It depends, is what we like to say. But the way
Right.
you're describing it, if you look at our paperwork, like if you go through our PPM, et cetera, when you do the elections and all that kind of stuff, it
Mhm.
will say, are you coming in as an individual? Are you coming in as an LLC? Are you coming in as a trust? Are you coming in as a self-directed IRA? So in that case, what you've told me, they would be coming in into a syndication. That assumes that you've set up a syndication, right? And then they would be coming in as, let's just say, an LLC. And so basically, they could be a large, right? Let's say you're raising 5 million, and they're coming in at 2.5 million or whatever. And a lot of
Right.
times, they'll negotiate a different deal because they're bringing that much money to the table. So then you might need to change your paperwork. So when we had that situation happen where we had to go back and revise our paperwork in order to accommodate what they were asking, because the bottom line is that anything that you do when you got your deal put together and you got your paperwork out there, anything you do that changes the structure of that deal has to be disclosed. So as Mauricio always says, and like I said, I was in his mentor group, so I heard him say it over and over. You can pretty much do anything you want to do, but you have to disclose it. And obviously stay within the laws, but you have to disclose it. So in the case that you said, they would come
Right.
in as a LLC, as a, corporation, whatever. They would check that box, and then they would just be a LP, just like you and I would be at $100,000, but they would obviously own more.
Got it. Got it. Thank you very much.
You're welcome.
And Steven, you're up.
Hey, how you guys doing? And thank you very much for this. This is really
Sure.
informational for me.
Good. Good.
Just a question. I think you already went over it on the 506C, but I'm just trying to make sure what you're saying there on that bullet for accredited investors only. Does that mean they have to have $1 million net worth or at least $200,000 to put into minimum?
Yeah, it could be
Okay.
that. It could be that they would have 200,000, but really the more likelihood is that they have a gross income for the past 2 years of 200,000 or more.
Okay.
But what you said is also true. That's a new law that they put into place that if they invest 200,000, it's automatically assumed. That's assuming that the minimum investment value is 200,000. So in your case, if you're offering 100,000, they put in 200,000, that does not immediately qualify them. It would have to be a $200,000 minimum investment. So the likelihood that somebody's going to do that, like there's a lot of things that have to line up. So most likely your accredited investors are going to come from their net worth or from their gross annual income for the previous 2 years, which is 200,000.
Okay, great. And I have just one more quick question. 506B and 506C, when you're talking about what, if someone says, I think I talked to Chase about it, he asked like, what is it, a 506B or C? Like, when does that get decided and what, like, yeah, when does that get decided and where is that put
Yeah.
down on in the
Great
deal?
question. That's one of those details that you're going to have to decide and tell the SEC lawyer, because that's going to be one of the first questions that he asks you.
Oh,
Is it,
okay.
are you doing this at 506B or a C? How do you decide? Well, if you feel like you have enough people in your network, friends and family, to go get them, it's much more easy to use in the 506B because you don't have to worry about you don't have to spend money on advertising. You don't have to worry about, anything in your ads. You're just going to get the people you know. Now, on the flip side of that, the 506C is easier because you literally don't have to follow any of the rules. It doesn't matter if if you know them or you don't know them or they're accredited or non accredited, but the only people that are going to come in are the ones that are accredited. So it kind of takes a little bit of pressure off. But when you get down to the bottom line and you say, oh, are you accredited or not accredited? And you want to kind of lead with that question because you don't want to spend 2 months talking to a guy who you think is going to invest with you, and then you find out he's not accredited and you have a 506C set up. So he can't invest with you. So it's very important that you talk to your potential investors to figure out where they're at, obviously, depending on whether you're in a B or a C. Does that make sense, Stephen?
Yeah, Teresa, thank you so much.
You bet. You bet.
And then, excuse me, Satari's up.
Okay.
Yeah, a quick question around is there a specific just from a terminology sake between an SPV or a um what do you call it? Well, an LLC. Like, is the LLC the structure of it, and SPV fund is that? How do you like language? Because when people ask me and I use the language, they're like, SPV fund. I guess.
Yeah, so that's a fund that refer like to I think a single purpose vehicle. I'm not really sure if I got
Yeah,
the acronym right, but
Special
special purpose
purpose.
vehicle. Yeah, special purpose
okay.
vehicle.
Yeah. So that's a fund that is actually going into but then you mentioned it contrasting it to an LLC, but that's totally different. Like that's an apple and an orange there. Those aren't the same. So be more specific. You started to say people ask you, what do they ask you?
Well, they asked me how they can, how we could raise money, and then they say, okay, well, you got to create an SPV fund, uh,
Ah,
and how is
okay.
that different
So
from?
they're running to raise capital for you?
Yeah,
Okay. Okay. And again, thank you for bringing that up. I had that in my notes and did not. So this is one of the things, and Mauricio would say, this is the number one thing that syndicators are doing wrong. And that is you absolutely cannot pay people to capital raise for you. And that's why you're saying that, Satori, is because if they create a fund and then their fund invests in your deal, they are liable. They take care of all the fund paperwork. They do all their SEC documents, and you can accept them. Obviously, you want to do your due diligence to be sure they really are a fund and they're set up legit and all that kind of thing. But in that case, that is the only way that they can raise money and come into your deal. Now, there is some legislation in the works that may or may not happen. They've been talking about it for over a year, and it's called a finder. And literally, then we would be able to pay finder's fees to capital raisers. But at the present time, the only way to get someone else to raise money for you is for them to create some kind of a fund and then invest into your deal. Does that help answer?
absolutely. Yeah, appreciate it. Thank
Okay,
you.
perfect.
There was one other question I just wanted to for the group. Tim already answered it, and so did Laura. But do you set up a 506B or a 506C once for every deal someone goes after?
Well, you wouldn't set up a 506B or a 506C until you are approved through the LOI process, right? So you just don't want to go out and set that up when you think you're going to get a property. You want to be far enough down the road, which normally is once the seller has agreed to your LOI conditions, then you would start this process. Now, what I first thought you were going to ask there, and I'll just go ahead and answer this question if I misunderstood what the question really was. Every time you do a deal, you are going to have a separate 506B or a 506C for every property that you take under contract. The only exception to that is, and we've talked to you guys about that, is that if you get into a customizable fund, which we have done as Next Legacy Group, and that gives us the opportunity to continue to raise capital under the same umbrella, even though we have different properties. But that's a special circumstance, and you have to be sure that either your SEC attorney knows that you want to do a customizable fund. Some of them don't even know what those are. I've asked some people, and they don't know what that is. Other people do. So hopefully, I answered the question either way there.
I think the latter is what he was getting at, is do one for each
Okay.
deal.
Yeah. Okay.
So Michael Hance had a question earlier. Is there normally a gradation in the benefits for accredited versus sophisticated under the 506B?
Uh, a, a gradation. I didn't
Gradation.
understand.
I'm wondering if he means like, um, and Michael, you can clarify if you want, but I think like any extra benefit, I guess, by being accredited versus a sophisticated under a 506B.
No, not to my knowledge.
John has his
Any
hand back
others?
up.
Okay.
I'm sorry.
That's
I'm
okay.
interrupting your show here.
That's all right. That's
No,
great.
it's good.
I love it.
The last gentleman that was talking brought up another question. So if that company that I was talking about earlier is
Yeah.
funded by funds or a fund, and they're trying to invest in your deal, is there a difference with that? Does that make any difference, or
It depends on
money?
it depends on how they're set up. It depends on how they set up their fund or whatever. You know, if you're saying there's funds coming in, so in other words, you're saying that maybe they're bringing $1 million to the table and there's 5 guys who are throwing in 200,000 or something like that. Potentially. Right? Is that what you're referring to?
Uh, Not really, but if the company
Okay.
is funded, right? Or I'm sorry, if the company has funds set up, like
Okay.
funds, if they have those set
Okay.
up and can they use those to invest in
They
other
can.
entities,
Uh-huh.
or
Yes, they can. But there are special rules for business for accreditation. It's not the
okay,
same like levels. And
okay.
I apologize, I can't remember right now what that is. I just haven't looked at that for a
No,
while.
no, I'll research that. I was just curious
Yeah.
if I did have to research, but I appreciate it.
Yeah. Yep.
Thank you.
You're
And then
welcome.
Lucas, if you're still on, I saw you had a
Yeah, I'm
question.
still on.
Okay.
Yeah,
Hey,
it's 5
Lucas.
million for the companies. Hey, how are you doing?
Say that again, Lucas, 5
Yeah, 5
million.
million. 5 million's net worth, yeah, for the company.
There you go. Thank
It
you.
was the accreditation for that. And then also I wanted to bring up it's a small caveat, like with the Bs, that your non-accredited have to be savvy investors, and that's not just it's partly your due diligence to kind of assess whether or not they're a savvy investor or not, but they also have to self answer that in your questionnaire as well. So if they're filling out the questionnaire when they're putting in their money, and they say they don't believe that they're savvy, then they automatically rule themselves out, and that can happen.
Yeah, absolutely. Yeah, and that's where on this slide it says the sophisticated investors, savvy is a great word there. It probably makes us have a better indication of what that means. And like Lucas said, you do have to complete that form that says that. And I mean, it's up to you as the deal sponsor to kind of sniff that out in advance. You should be making sure, and the whole point of this law, and you guys may have heard Grant talk about it, the whole point is to not take advantage of people who aren't smart, if you will. And I put air quotes around that, not smart. I'm not really sure, who gets to determine that, but I guess the government in this case. But anyway, savvy is a great word. I appreciate you filling that in, Lucas. That's good, great information. And like he said, there's a lot of information. Again, if you're an LP investor, you fill out these forms and you see that, and then you can help other investors answer those questions as they get through them themselves.
And then Teresa, another one that I wanted to bring up too was the 506C when you're doing accreditation verification. You as a sponsor, and this I would never ever exercise this option without consulting your SEC attorney first. But if you know for certain, for sure that the person you're bringing in is accredited and you've known them for a while and you know that they are accredited, then you do not have to provide that documentation. They do not have to do that. And that you just have to have a firm conviction of knowing for sure that they are accredited. And that just puts you in more liable position. So as an operator, it is not advised to ever do that, but you may have people come to you that you know for sure, like you were talking about that other guy that may have like 50 properties or something like that. There's no way that he's not accredited. But if they're just telling you that the first time, that's not really a substantial relationship. But you had a substantial relationship for like 2 or 3 years, and you're like, yeah, I've seen these properties, I've seen them accumulate them, I know for sure that that person's accredited, then that person you wouldn't have to necessarily get an accreditation letter for your records. But this is something that you'd want to make sure that you always work with an SEC attorney with and get their blessing before you do it. But I got that straight from an SEC attorney, so.
Yeah, but I would venture to say it's always better safe than sorry. So I would get it anyway. If you know they are, then it shouldn't be a problem for her to get it. I would err on that side than making the assumption.
Good information. Thanks. Anything else? Jason, I'm not leaving any room for you, bud.
No questions so far. I think this is a good topic.
All right. So one of the things just I wanted to highlight, we kind of already touched on this a little bit, but you will have to fill out a form, and basically it's a bad actor. And some of the questions on there, do you have a criminal record? Is there anything with the SEC that you've had, problems with? FINRA? Are there any court injunctions? So there's questions that your investors are going to have to answer. So you do want to be sure that you know the answers, to these questions, or at least have a good idea of whether there is, people that you've dealt with. Like Lucas said, you've known him 2 or 3 years, and in my case, that particular guy, I went to high school with him, so I've known him for a few more years than that. But you do want to know, because especially, if you get into a large deal and you're doing, big amounts, you want to be sure that you do your due diligence on the people that are investing with you, because their criminal record can end up taking you down. So just a couple more things that I wanted to touch on, Reg D and blue sky filings. And I had to put in the clouds, because really that's all you're paying for is literally blue sky. For every time that you bring an investor into your deal, doesn't matter if it's a 506B or a 506C, you have to complete a blue sky filing. And also you have to complete the Form D, and it's now online, and it's called Edgar. And so as soon as you accept the very first payment, you have to file the Form D on Edgar. Like I said, we did ours. Our SEC attorney helped us through this. This is all stuff that they will help you through, but you need to be aware. And then every time someone invests from a different state, you have to pay a blue sky filing. For example, in the state of Alaska, the blue sky filing is, I think it was $500 or $600. Some are zero. Indiana is zero. Illinois is $350. Missouri is $100. So they're all over the map, and you have to file those within 15 days of receiving money from your investor. So as soon as your investor's money hits your bank, you have 15 days to complete that, or you will get penalized. And perhaps even, they can yank your deal or your Form D exclusion completely, and get you in some bit of trouble there. So now, if you have say you have an investor from Florida, and then, a week later you get another investor from Florida, you do not have to pay that again. You only pay that one time. So this is
Per
quite
deal.
an extensive, I'm sorry, per
Per
deal.
deal.
Yes, thank
Per
you.
deal. Yeah.
Yes, right,
Mhm.
right. Yeah, so once you pay that on this particular deal, then you're complete. You can file these yourself. I know that Premier Law Group, when I worked with them, filed those for us. They kept track of them. We just filled out a spreadsheet, and they did that. And then some of the states even have an annual fee. So in a year, we're going to get notices that we owe, that Blue Sky filing again. So the Blue Sky keeps on giving. So these are just things that, you just want to know and ask questions. And this is more for just for you to kind of look at later. I don't need to go through this, but I wanted to put something like this in here to give you the idea that keep in mind when you're doing your legal documents, everything that you are expecting to do, where the money's going, how much you're earning, all of that has to be disclosed. There is no hiding anything. And literally that is where the SEC comes down. Most of the times I've heard many stories from Mauricio. So many times the people who get called on the carpet on things that cause the SEC to come down on them, a lot of times it's even one lawyer mad at the other lawyer and knowing that they're skating by doing not what they're supposed to do. So it may not even have anything to do with you, but just know that you've got to ask enough questions to be able to be sure that you're getting the right information out there. So most of the time when there's a complaint filed against a syndicator, it is usually because one of the investors had an issue. They went to a lawyer and then they decided, okay, well, that's not right. We're going to go after them. So again, I just emphasize how important it is that you disclose everything. Everything you even think about needs to go into writing. And this is just one example of something that you'd want to disclose in some way, shape, or form. It just has all the fees listed so that it's very clear on where you would be. And I just gave a range because I know a lot of times you're confused about where those come from and what they all mean and that kind of thing. So they're all there for your reference when we send this out to you. And finally, ask questions now to avoid tight spaces later. So if you've got anything else you want to know, I'm happy to try to help. My information is there. I appreciate your time. I didn't mean to take this much time tonight since we're a short night, but you guys had fantastic questions. I really appreciate your due diligence on trying to learn. So if there's any further questions, we can finish up with that. Or Jason, it's back to you.
Yeah. So what other questions do you guys have? We have about 4 minutes or so. Steven, go for it.
Hey guys, I just want to say thank you very much for this. This was super, super informational for Elaine and I. We just submitted an LOI, so we're really looking for attorneys right now and interviewing them and stuff like that. Just out of your experience, we're in New Jersey, so for SEC lawyers versus transaction lawyers, like what is like the typical like fees that they would charge, like a range of fees, like in your experience?
Yeah. So generally the transactional lawyer, I mean, really for the most part, all they're doing for you is that PSA. So it's almost like and if other things come up, like obviously I'm in that lawsuit. So then I hired a different lawyer to do that. So there's always other things that come up. But that transactional lawyer, I paid him about $3,500, $5,000, somewhere in that range. Very, very reasonable, really. Because in my case, in that particular case, he did not create the document. He only redlined it. Basically, he reviewed it, we drafted it, and sent it back. So somewhere in the probably 5,000 to 7,000. Now the SEC attorneys, there's a pretty wide range there. I've heard some as low as $10,000 per deal that you do. I know that I paid over 20,000 for my first deal. So there's a pretty wide range there. And you bring up a great point, Stephen, because that money has to be paid in advance. I mean, those lawyers aren't going to work for you. And you really don't want to use any capital raise money for that, because if something does go wrong, that's money you're out, and then you would have to pay that back to your capital raise, your investors. So that's really money that you need to have coming out of your pocket, along with the escrow money, and that's usually right up front that you have to pay that.
All right. Thank you so much. I really appreciate
You're
that.
welcome. Yeah, if anything else comes up, feel free to reach out.
Will do. I already am battering Jason all the time for information and help. So you guys
That's
have
all
been
right.
great.
It's all
And
good.
Tim, we're working with Tim too, starting next
Oh,
Saturday. So you guys have been
Nice.
nothing but a great asset for us and great help for us, So thank you.
Yeah.
Perfect.
awesome.
You bet.
Garth has one question. Do each of you guys have your own personal lawyers in case of lawsuits from investors or partners?
I have
I
too
don't
many
think we.
lawyers, Garth. I don't want any more. But yes, I mean, we have resources to be able to resolve those issues, right? So, I mean, I do, and the other partners can speak for themselves.
I have not lawyered up yet, so I'm hoping not to have to lawyer up. But if I do, I'm sure we would.
I have attorney from before I even ever got into investing that can handle the real estate stuff. So I would fall back on him for my own personal use.
And I do not have a lawyer on retainer right now.
Mine's not on retainer. He's just in my Rolodex.
All right. So I know at the beginning of the call I had mentioned that we're stopping at 8 o'clock tonight. I believe Grant Cardone has a investor update, and I know a lot of folks were going to drop for that. And so therefore we're going to stop our call at 8 o'clock to allow folks not to have to toggle between the two. We were also planning on kind of giving you guys an idea of what we're doing with our new debt part of our fund. Um, but we can potentially do that next week and bring that up and show you guys how that works. And if you're interested ahead of time, I can absolutely send some information out to anyone who's interested, and we can, of course, talk to you about any of it at any point in time. So I want to say thank you all. The deck, we will send the deck out. We also have a YouTube page. All of these videos that we do, we record and post on that YouTube page, and so you can watch previous ones if you've missed old ones. But
And we'll
thank you
send
guys.
out the recommendations for the lawyers as well.
Yes, and we'll send out that lawyers. I did put an accountant recommendation. Somebody was asking for that in the chat as well. All right, cool. Well, thank you
Perfect.
all. Appreciate you. Have a great weekend, and we'll see you next
Thank
Friday.
you.
Thank you.
Thanks, everybody.
Bye.
Have a great weekend, everyone.
Thank
Have a
you.
good weekend.
Have a good weekend.
I don't know how many of you saw the news while people load in here, because we had about 3,000 people reach out to us via email, text, or phone calls this week about some stuff